To deal with such situations, we have acts like Unlawful Activities Prevention Act, National Security Act, Arms Act, Armed Forces Special Power Act. So let's discuss those acts. Hello everyone, I am Soumyasdiary. Welcome to Soumyasdiary. In our discussion on terrorism, we discussed how foreign money enters into our territory and contribute towards terrorism. That was a part of the picture. Let me show you the big picture. Foreign contribution can influence the political outcomes. Many times, countries do it to put a favorable regime in place. The new government may support the country and help it in its foreign policy design. Similarly, foreign contribution may affect public opinion if it can influence the media to publish its narrative, thus create a favorable public opinion for the country. A foreign contribution can influence civil servants and judges as well. Thus, it can construct a favorable input for government decision making. In fact, in late 60s, it was found that the international firms, including CIA, were having relation with many organizations in our country. You might be reading about S. Nambi Narayan case in the editorials nowadays. You can imagine the ripple effect on our national security, our national interest. Thus, in 1976, Foreign Contribution Regulation Act was passed. It aims to regulate the acceptance and usage of foreign contribution and foreign hospitality by associations and persons working in important area of national life. Recently, there was an amendment to the Act to make it more contextual. It bars public servants to accept foreign contributions. If you are an NGO group and you got foreign contribution, you can avail it in a designated account. To avail foreign contribution, the office bearer of the NGO should have Aadhaar card. It is a mandatory criteria. NGO group cannot show more than 20% of its administrative expenditure from the contribution, and it cannot transfer to the person or organization who is not allowed for the foreign contribution. So the screw is tightened by the government. Now the question arises, was it necessary? So my answer is, might be. Because nowadays, in a globalized world, foreign countries are running their propaganda through NGO groups by giving the donations. If it is a white source, it is okay. But we need to check the black one to protect our national interest, to secure our national security. So, who can register? If you are an entity registered with Society Registration Act, Indian Trust Act, Charitable and Religious Trust Act, Companies Act, you can apply for it. Your application will be forwarded to Intelligence Bureau. Based on the feedback of Intelligence Bureau, FCRA department takes the decision to allow it or reject. Once you get approval, you get a permanent account number, and your organization need to maintain a separate book for contributions and utilization. So there is a filter here. However, finance is not the only dimension of terrorism. In our last discussion, we discussed on many aspects. There may be a psychological orientation or a design to disrupt the public order. To deal with such situations, we have acts like Unlawful Activities Prevention Act, National Security Act, Arms Act, Armed Forces Special Power Act. So let's discuss those acts. Unlawful activity refers to any action taken by individual or association intended to disrupt the territorial integrity and sovereignty of India. Central government provides a list of such activity through its official gazette. In 2004, Terrorist Act was added to the list. Thus, unlawful activities Prevention Act 1967 aims at effective prevention of unlawful activities in India. Still, the agencies found it really tough to stop the activities. We discussed in our video on terrorism how they do it. Thus, to stop alibi problem, Unlawful Activities Prevention Act 2019 amendment was drawn. It empowers the central government to designate individuals as terrorists. The central government may designate any organization as terrorist organization if it commits or participates in acts of terrorism, prepares for terrorism, promotes terrorism, otherwise involved in terrorism. A list of terrorist acts is given in the schedule to the act. To know more, please refer to my blog on the topic. Now, let's discuss about a situation. You are a public authority. You have intelligence input about a person who is attempting to do a serial bomb blast in your city. You don't have evidence for that because the act is not committed. Now, you need to stop him before he acts. There must be a procedure to stop him. So such kind of arrangement is known as preventive detention. National Security Act allows preventive detention. Indian Constitution provides rights of the detainee. However, it allows exceptions for enemy alien or persons detained under law providing for preventive detention. Under this act, a person can be detained up to 12 months without charge. He can be held for 10 days without being told the charges. He can appeal before a High Court advisory board but will not be allowed a lawyer during the trial. No first information report is registered, thus the data is not available to National Crime Record Bureau. So there are denial of rights, right to consult, right to be defended by legal practitioner of his choice. So these are mentioned in Article 22 of the Indian Constitution. Then there are rights under CRPC Section 50. Any person arrested has to be informed on the ground and has the right to bail. Moreover, the government conceals the information which it considers to be against public interest to disclose. Arms Act 1959 was enacted to consolidate and amend the law related to arms and ammunition. The Act and the rules made thereunder regulate the acquisition, possession, use, manufacture, transport, sale, transfer, export and import of arms and ammunition. Law enforcement agencies have found a growing nexus between possession of illegal firearms and commission of criminal offense. Thus, to curb crimes related to illegal firearms and to provide effective deterrence against violation of law, there is need of a legal regime. We discussed our video on terrorism that cross-border illegal arms trafficking is a threat to national security. Thus, it must be checked. Simultaneously, there is also requirement of rationalizing and facilitating the licensing procedures for use of firearms by individuals and sportspersons. Thus, an amendment has been enacted to the Act. It provides definition of new offences, enhanced punishment for existing offences, and limits the number of licensed firearms that an individual can have. To know more about this aspect, please refer to my blog. The link is given in the description box. However, these legislations may fall short when we encounter the problems in Northeast, particularly the insurgency. We discussed the reasons in our video on Northeast insurgency. There are conflicts among the ethnic groups. There are strong criminal nexus. So the civil administration may find it tough to control if there is a disruption in public order. So a special arrangement is needed here. The armed forces need more power to deal with such situation. Such arrangement is done under Armed Forces Special Powers Act. If there are differences or disputes between members of different religious, racial, language or regional group or caste or communities, the central government or governor of the state or administrator of the union territory can declare the whole or part of that state or union territory as a disturbed area. As per section 3, it can be invoked in places where use of armed forces in aid of the civil power is needed to deal with the situation. A official notification is published in the Gazette. The Armed Forces Special Power Act provides power to armed forces to restore public order in disturbed area. Once this comes into force, gathering of people more than 5 in a group is prohibited. If a person is found in contravention of law, he will be warned. The act empowers even to use force or even open fire. On the basis of reasonable suspicion, Army can arrest the person without warrant. It can enter and search a premise without warrant and ban the possession of firearm. The arrested person is handed over to the officer in charge of the nearest police station with a report. So, I hope you got an overview of the important legislation related to internal security. Thank you very much. Thank you very much for your precious time. If you like the content, please like, share and subscribe to my channel. Such value-added content, stay connected to it.